Judgment in the appeal, the Queen on the application of Lumsdon and others against the Legal Services Board.
Lord Reid will explain the judgment of the court.
This appeal has been brought by a number of barristers practising criminal law. They are challenging the approval by the Legal Services Board of a regulatory scheme for advocates practising at an upper level in the criminal courts. Under the scheme, they are required to undergo assessment by judges in order to be allowed to continue to practice. The appellants challenge the legality of the scheme under the EU Services Directive, under which regulatory schemes restricting the exercise of a service activity must comply with a requirement that the objective pursued cannot be attained by means of a less restrictive measure. They argue that the objective of this scheme could have been achieved by a less restrictive measure, namely, a scheme under which judges could report barristers whose performance in practice was considered to have fallen short of an acceptable standard. The appellants lost the case in the courts below and now appeal to the Supreme Court. The court finds it unnecessary to decide a dispute between the parties as to whether the Services Directive applies to the scheme. On the hypothesis that it does, the question is whether the scheme meets the requirement that the objective pursued cannot be attained by means of a less restrictive measure. That requirement gives effect to the EU principle of proportionality, and much of the court's judgment is devoted to a discussion of how that principle should be applied. One important point emerging from that discussion is that where a national measure restricts the exercise of one of the fundamental freedoms protected by the EU treaties, as in the present case, and the purpose of the restriction is to protect a public interest in an area where EU law has not imposed complete harmonization, the national authorities possess a margin of appreciation in deciding on the level of protection which should be given to the public interest in question. In the present case, the scheme is designed to protect the interests of those who receive advocacy services in the criminal courts, and also the public interest in the proper administration of justice. The Legal Services Board found that there was a body of evidence indicating serious cause for concern about the poor standard of some criminal advocacy. It also found that poor advocacy could have serious consequences for defendants, victims, and witnesses, and for public confidence in the administration of justice. It considered that a scheme applicable to advocates generally was justified in view of the gravity of the risk and the absence of evidence supporting the adoption of a more selective approach. It also noted that the scheme was to be reviewed after 2 years and that it could be adjusted on the basis of evidence gained from its implementation. A scheme of this kind provides a high level of public protection precisely because it involves an individual assessment of every advocate wishing to practice at an upper level. Whether such a high level of protection should be provided is exactly the sort of question about which the national decision maker is allowed to exercise its judgment within a margin of appreciation. It is true that the evidence in the present case did not enable the level of risk to be quantified with any precision, but that did not preclude the board from finding that it was unacceptable to run that risk. The court does not regard the judgment made by the board in that regard as falling outside the appropriate margin of appreciation. Since the only way of reducing the risk so as to provide the desired level of protection for all members of the public involved in criminal proceedings at an upper level is to have a scheme of the kind proposed, it follows that the scheme is proportionate to the objective, notwithstanding the inconvenience caused to competent members of a profession. The Supreme Court therefore unanimously dismisses the appeal.
The court is now adjourned.